So welcome back to the mediation course, and we were discussing the Mediation Act of 2023. In today's session, we will delve into Chapter 5 of Mediation Act. This chapter outlines the procedural aspects of mediation. It is very crucial as it provides the frameworks how mediation is required to be conducted, ensuring the process of mediation is fair, efficient, and conducive to resolve the disputes amicably. Section 13 of the Mediation Act addresses the territorial jurisdiction for conducting mediation. This provision ensures the mediation is conducted within the appropriate legal framework and under the oversight of competent court or tribunal. So the general rule which is envisaged in this section is that the mediation must be undertaken within the territorial jurisdiction of the court or tribunal that has the authority to decide the subject matter of the dispute. That is, if a subject matter is falling within the territorial jurisdiction of that court, so within such territorial jurisdiction itself, the mediation is required to be conducted. This ensures that the mediation process is aligned with the legal jurisdiction governing the dispute, providing a structured and recognized framework for resolution of disputes even through mediation. But there has been an exception to this general rule under this section itself, which provides a flexibility to the parties by allowing the mediation to be conducted outside the territorial jurisdiction of the competent court or tribunal or through the online mediation. But it should be conducted with the mutual consent of the parties to this arrangement. This flexibility accommodates the parties' convenience and modernize the mediation process by incorporating online options, making it more accessible for the parties to resolve their disputes. Further, this section also includes a clarification for the enforcement and registration. That is, there might be some certain doubts, like if a party resolve their disputes outside the territorial jurisdiction of the competent court, or if the parties resolve the disputes through an online mode, how that is required to be enforced. In order to remove that doubt, it is clarified through this section that if the parties agrees to conduct a mediation outside the territorial jurisdiction or through online mode for the purpose of the enforcement, the arrangement has been made to register the mediation settlement agreement, which will be deemed to have been undertaken within the jurisdiction of such competent court or tribunal. This ensures that the mediation settlement agreement is enforceable and recognizable within the legal framework of relevant jurisdiction, maintaining the integrity and enforceability of the mediation agreement. So this section balances the need for legal structure with the flexibility required to accommodate the parties' preference by stipulating the mediation be conducted within the territorial jurisdiction of the competent court or tribunal and allowing for exceptions with a mutual consent, that the act ensure both the integrity and accessibility of the mediation process. Coming to the next section of this chapter, that is section 14 of the Mediation Act, it outlines specific conditions under which mediation proceedings are considered to have officially commenced. This provision ensures the clarity and certainty about the initiation of the mediation proceedings, which is crucial for proper timings and management of dispute resolution. So, when there is a pre-existing agreement between the parties to settle a dispute by means of mediation, the mediation proceeding commences on the date when the party receives notices from initiating the mediation process. This provision emphasizes the importance of formal communication in triggering the mediation process and ensure that the parties are aware of the commencement. So that means, if there is a pre-existing agreement, in that case, any one of the parties, when the dispute has been arisen, receives the notice from one party, such initiation will take place when the party receives such notices. When in other cases, that is with a consent to appointment, when there is no pre-existing agreement, if the party agrees to appoint a mediator of their choice, the mediation proceeding commences on the date of mediator consents to the appointment. This ensures that the process is officially recognized only when a mediator is ready and willing to facilitate the mediation. Next, the application to mediation service provider. In a situation where one party applies to a mediation service provider to settle the dispute, the mediation proceedings commence on the date a mediator is been appointed by the service provider. This provision ensures that the mediation process starts promptly once a mediator is assigned, even if the parties did not pre-select the mediator. So this implicates that the clear delineation of the commencement dates ensures that all the parties know when the mediation process is officially begins. This clarity helps in scheduling and adhering to the time limits and understanding the progression of mediation process. Emphasizing the formal communication, that is by means of notification or by means of consent by a mediator as the trigger for the commencement of the mediation process. Ensuring the process is transparent, that all parties are adequately informed and prepared for mediation. So this section has been framed in order to ensure or make aware to the parties when the mediation process will actually take place. That is, it lays down 3 criteria. 1, when a dispute has been arisen and there is a pre-existing mediation clause, and one party sends a notice and the other party receives it, from that place the mediation process will take place. The second thing is that When an application for the appointment of mediator is made by the parties and the mediator accepts such application or appointment of such to be a mediator, during that time the mediation will take place or commences. In the third scenario, that is when the parties request the mediator service providers to appoint a mediator for the settlement of their disputes, and the mediator service provider appoints the mediator to conduct such mediation, during that scenario the mediation will commence. This provision accommodates various scenarios for initiating mediation, whether through existing agreement or mutual consent to a mediator or application to a service provider. This flexibility supports the diverse ways in which the parties may approach the mediation, making the process flexible, adaptable to different circumstances. Section 14 provides a structured framework for determining the commencement of mediation proceedings by specifying clear conditions and dates for the start for mediation. This ensures transparency, proper communication, and flexibility in initiating the mediation process. Understanding this provision is essential for both the parties and the mediators to ensure the mediation process is correctly and efficiently initiated. Moving on to the next section, this section provides for the comprehensive guidelines for how mediation should be conducted. The provision designed to ensure the mediation process is fair, impartial, and effective in resolving the disputes. The mediation process must be conducted in the manner specified by the relevant regulations or guidelines, wherein this section empowers the Council, that is the Mediation Council of India, with the previous approval from the central government, may notify and make regulation consistent with this act. And section 52 empowers to make regulations for the council to make these regulations, and this ensures that the process adheres to the established standards and practices, providing a consistent framework for the mediators and the parties. So the act is yet to be enacted and enforced. The act is yet to be enforced, and once the act is been enforced, the central government has the power to establish the mediation council, and once the mediation council is established, by means of section 52, the mediation council will come up with such standards as to how the mediation is required to be conducted. Further, this section enumerates about the independence, neutrality, and impartiality, wherein it lays down the role of the mediator. That is, the mediator is required to assist the parties independently, neutrality, and impartially in their efforts to reach an amicable settlement. And this is the fundamental principle of mediation, that is to maintain the integrity, trustworthiness of the mediation process. Further, this section, that is section 50, also lays down certain guiding principles in order to ensure the independence, impartiality, and neutrality. That is, mediators must be guided by the principle of objectivity and fairness, ensuring that the process is equitable for all the parties. It also mandates that the mediator must protect the voluntariness, the confidentiality, and self-determination of the parties, allowing them to make their own decision regarding the dispute. That is, the mediator should not bring his opinion to the table at the time of discussions or negotiating between the parties. He should just facilitate between the parties to reach an amicable settlement. Further, this section also mandates certain professional and ethical standards to be adhered by the mediator, that the mediators conduct themselves appropriately and uphold the integrity of the mediation process. It also provides certain flexibility measures to a mediator to take various measures deemed appropriate based on the circumstances of the case. This may include meeting with the parties jointly or separately, that is, he may call the joint sessions between the parties, or he may even conduct the caucus sessions whenever he feels appropriate to have such. Convening the mediation as often as necessary, that is, whenever it is necessary, he may call for caucus session, he may call for joint session, and such flexibility allows the mediator to tailor the process to the specific needs of the disputes while ensuring the orderly and timely conduct of the mediation. But there are certain exemptions to this flexibility process, that is not bound by the strict rules of Civil Procedure Code or neither the Indian Evidence Act. That is, he should not follow the procedure that has been laid down in the Civil Procedure Code, but neither the Indian Evidence Act, because the mediation process is flexible in nature, and the mediator to adopt a more flexible and less formal approach which can be more conducive to reach to a settlement. Further, this section also envisages and also provides both the parties as well as the mediator to choose the language as appropriate. With the consent of the parties, the mediator determines the language or languages to be used during the mediation process. This ensures that all the parties can communicate effectively and understand the proceedings, which is crucial for a successful mediation. So this section provides a robust framework for conducting the mediation, emphasizing the fairness, flexibility, and effective communication. By adhering to these guidelines, mediators can facilitate a more efficient and amicable resolution of dispute, ensuring that the process is both fair and tailored to the parties' needs. In order to ensure the fair conduct of the mediation procedure, Section 16 of the Mediation Act delineates the specific responsibilities and limitations on the role of mediator in the mediation process. This section underscores the mediator's functions as a facilitator who aids the parties in reaching to voluntary resolution without imposing any decisions. So the mediator roles is just a facilitative, that is, to facilitate a voluntary resolution of dispute. That is, to facilitate a voluntary resolution, this involves communicating each party's views to the other to the extent agreed upon by the parties. That is, the parties, whatever the views that has been communicated to the mediator shall disclose such discussion to the other party only when the party has agreed to disclose that. The party assists in identifying the key issues. That is, the mediator will assist the parties in identifying the key issues, advancing the mutual understanding, clarifying the priorities, and exploring the potential settlement by means of generating options for resolving of the disputes. Emphasizing on the party's responsibility, the mediator's efforts are aimed at helping the parties themselves to arrive at an amicable settlement, ensuring that the decision-making power rests entirely with the parties themselves. Mediator must explicitly inform the parties their role is solely to facilitate the mediation process and not to impose any settlement. That is, the mediator shall not impose any settlement, and the mediator cannot assure that the mediation will necessarily result in a settlement. This clarification ensures that the parties understand in a settlement, that is, this is a party-centric discussion wherein the party themselves reach to an amicable settlement. This provision reinforces the principle of self-determination, where the parties retain the control over the outcome of the mediation process. By emphasizing the mediator facilitates but does not decide, this section empowers the mediation process and its outcomes. It promotes a collaborative approach where the parties work together towards a resolution. The mediator role as a neutral facilitator helps to build trust among the parties in the mediation process. Knowing that the mediator will not impose solution encourages upon the honest communication, which is vital for the effective mediation. Clearly defining the mediator roles help the parties to manage their expectations. Further, this ensures that the parties are aware of the mediator's function and the nature of mediation process, which can prevent the misunderstanding and foster a more productive mediation environment. Section 17 of the Mediation Act clearly defines the limitation of the mediator role concerning the involvement in the mediation proceeding. This section ensures the mediator neutrality and confidentiality of the mediation process are preserved. So this section prohibits a mediator from acting as an arbitrator or as a representative or counsel in any judicial proceedings for any party in an arbitral or a judicial proceedings related to the dispute that was subject to the mediation. That is, if a mediator is appointed by the parties, in such scenario, he cannot act as an arbitrator, he cannot act as a counselor in any of the judicial proceedings or in any of the arbitration proceedings. This ensures that the clear separation between the role of mediator and other legal roles, maintaining the mediator's impartiality and integrity of the mediation process. Prohibition of being witness. Even the mediator is prohibited to be present as a witness in a witness box in an arbitral or judicial proceedings. Further, this provision protects the confidentiality of the mediation. That is, whatever that has been discussed during the mediation process shall not be disclosed in any proceedings. Either it may be in a form of arbitral proceedings or in the judicial proceedings. Even he cannot be a witness in such case. And this ensures that the confidentiality of the mediation proceedings is being maintained and are not placed in any position where they might have to disclose the information shared during the mediation process. By prohibiting the mediators from acting as arbitrator, representative, or witness in related proceedings, reinforces the integrity of the effectiveness of mediation. Section 18 of this Act demarcates the time frame for the completion of the mediation proceedings. The mediation must be completed within 120 days from the date the first appearance before the mediator. That is, we discussed with respect when the mediation proceeding initiates. So from the date of the initiation of the mediation proceedings, the mediation should be completed within 120 days. And this provision sets a definitive timeline ensuring the mediation does not become a prolonged process and encouraging the parties to engage actively and diligently in resolving the mediation. In case if the party or the dispute was not able to settle within 120 days, it may be extended for an additional period of 60 days if the all parties agrees to extend. This allows the flexibility in case where the parties are close to reaching an agreement but need more time to finalize the settlement. However, the total duration for the mediation, including an extension, cannot be exceeded beyond 180 days. This limitation balances the flexibility with the need to avoid indefinite delays in the proceedings for resolving of the disputes. The time limit provides the legal certainty for the mediation process, helping the parties to plan and manage their dispute resolution efforts, knowing that there is a defined and point can also be motivate the parties to engage more constructively and resolve the dispute within the allotted time. Further, Section 19 of the Mediation Act outlines the requirement and procedure for creating an authenticate mediation settlement agreement. This ensures that the settlement reached through mediation are formalized and legally recognized. A mediation settlement agreement should be written agreement resulting from the mediation that settles some or all the disputes between the parties and is authenticated by the mediator. This formalizes the resolution and ensures that it is documented and recognized legally. The terms of the mediated settlement agreement can be extended beyond the dispute initially referred to mediation, allowing for a comprehensive settlement of related issues. So this section also empowers that whatever the dispute that was been referred to the mediator initially, the mediator may go beyond that matter and settle all the disputes or the related disputes to that matter which was referred. This ensures that the dispute between the parties is being settled amicably and beyond the subject matter as well. Any agreement that is void under the Indian Contract Act will not be considered a lawful mediated settlement agreement. That is, a mediated settlement agreement should adhere to all the provisions of Indian Contract Act. Further, the section formalizes the agreement, that is, it should be a written and a signed agreement. That is, once a settlement is been reached, must be reduced in writing and signed by the parties and by a mediator. This step is crucial for the enforceability of the agreement. The mediated settlement agreement must be submitted to the mediator, who authenticates it and forwards it with a covering letter to the mediator service provider in case the mediation is being settled or the mediator is been appointed by the mediator service provider, providing the copies to all the parties. In case if the mediator is been settled through a pre-existing clause, that is, the parties themselves have appointed the mediator, in such scenario, the mediator authenticates the agreement and provides a copies to the parties directly. This ensures that all parties have a formal authenticate copy of the settlement. The parties can make agreements regarding any disputes at the time during the mediation process. This flexibility allows the parties to settle the parts of the disputes or potentially the easing of resolution of overall conflict. This section explicitly includes recognition of the online mediation. This recognition of online mediation ensures that agreements reached through virtual mediation process are equally valid and enforceable. So the mediation settlement agreement is authentication of this mediation settlement agreement emphasizes or ensures the agreements are documented and legally valid and enforceable. The Act promotes the effectiveness and reliability of the mediation and dispute resolution mechanism. So this section, that is section 19, provides more emphasis towards the settlement of agreement by means of a mediation service provider or the appointment of mediator through mediation service provider, as well as the mediation settlement agreement that has been settled by the mediator by means of pre-existing agreement as well. But the section 20 of the Mediation Act provides the framework for the registration of mediation settlement agreement. It's not a mandate. It's not mandate for all the parties or all the mediator settlement agreement is required to be registered. It's an optional. This process ensures that the settlements are officially recorded by the parties, which can aid in their enforcement and recognition. The scope of this section is that the mediation settlement agreement, except those resulting from the court or tribunal referred mediation, that is court annexed mediation or tribunal annexed mediation, or Lok Adalat awards or permanent Lok Adalat awards under section 21 or section 21(22)(e) of the Legal Service Authorities Act 1987 may be registered. This provides a formal mechanism to record settlements that are reached outside this specific context. That is, if the parties can choose to register their mediator settlement agreement with an authority constituted under the Legal Service Authorities Act of 1987 or the central government, or the central government has notified that any authority for this purpose. This flexibility allows the parties to select suitable registering mechanism or authority based on their needs. Upon registration, the designated authority or a body will issue a unique registration number for settlement agreement. The unique identifier facilitates easy reference and verification of the agreement. So section 20 of the Mediation Act ensures that if the mediation agreement is being reached, it provides a mechanism for registration of such agreement with an authority that is been established by the central government or with the Legal Services Authority established under the Legal Services Authorities Act. So the parties can have an option to register such agreement. The mediator settlement agreement, where it has to be registered? So it has to be registered at the place where the authority or body within the territorial jurisdiction of the court or tribunal that has competence to decide the subject matter of the dispute. At such place, such agreement is required to be registered. That is, the Legal Services Authorities Act or wherein under that act where the authority has been established and the subject matter of such a dispute is within such competency of such authority of such court or a tribunal, the parties can register at such place. So this ensures that the registration is recognized within the relevant legal jurisdiction, aiding the enforcement and legal proceedings related to the agreement. So registering a mediator settlement agreement provides an official record of settlement. This can be useful for future references, enforcement, and in case where the terms of the settlement need to be verified or upheld by the court. An official register agreement may carry greater legal weight, ensuring that the settlement is recognized and respected by all the parties and relevant authorities. Having a unique registration number of being registered with the authority of the mediator settlement agreement, and an official record can simplify the enforcement of the agreement, making it easier to prove the existence and terms of settlement in any subsequent legal proceeding. Overall, Chapter 5 of the Mediation Act establishes a structured, comprehensive framework for mediation proceeding, ensuring efficiency, impartiality, and legal soundness. It mandates the mediation within the jurisdiction of the competent courts or tribunals while allowing flexibility for online or out of court jurisdiction mediation with mutual consent. Clear guidance for commencement and conduct of the mediation has been included. Mediator rules and ethical standards upholding the integrity of the process. A 180-day timeline for resolution of disputes through mediation promotes a timely resolution of disputes. The formalization and optional registration of mediated settlement agreement ensures their enforceability. Recognizing the online mediation reflects the Act's adaptability to the modern needs, making mediation a viable alternative to the traditional litigation, reducing the court's burden and fostering collaborative dispute resolution, also enhancing cross-border resolution of disputes. With this, we conclude over here Chapter 5 of the Mediation Act. Thank you.